Welcome to Victory, the authority in personal injury. Today, I have the honor of presenting 4 trial attorneys with Garces, Grabler LeBrocq. To my left, we have Sean McDonough, a certified trial lawyer. Pete Agostini, also a certified trial lawyer. All the way to the right is John Gagnon, a certified trial lawyer, and Ralph Cretella, who has a certification pending. He's qualified, he's taken the test, and he's ready to get that certification. And I've been a certified trial lawyer for over 20 years. So we're going to talk about what is the importance of using a certified trial lawyer when you have a collision or some sort of injury, whether it's construction, medical malpractice, nursing home, what the significance is of using a certified trial lawyer. John, you want to start off and just tell us a little bit about why it's so important to use a certified trial lawyer?
Sure. So a certified civil trial attorney, in order to get that designation, you have to try a certain number of cases, and you have to submit to a test before the Board on Attorney Certification, and then the New Jersey Supreme Court will determine whether or not you're qualified. So I guess from my perspective, when I'm dealing with another attorney, or if I was going to hire an attorney, my question would be, if they're not certified, why are they not certified? Because being a certified civil trial attorney doesn't necessarily guarantee that that attorney is a fantastic attorney, but if you're dealing with an attorney who's not certified, why not? Because that means that they haven't tried that many cases. And do you really want an attorney to handle your case who maybe they might be a great attorney, they might be very good at settling cases, but at the end of the day, do they try cases? Because that's when you get top dollar. That's when you get the real value of your case, when you're ready to go to trial.
So Ralph, you've just gotten your certification, taken your test, it's still pending. I would imagine you passed the test and you'll become a certified trial lawyer. What did you have to do to become a certified trial lawyer? What are some of the steps?
Sure. So the process for certification is actually quite a lengthy one. In fact, a lot of lawyers within our community complain about the paperwork process being the even more difficult portion of the application rather than the actual written test. So in order to even be determined eligible by the Supreme Court of New Jersey to sit for the test, you have to provide to them a list of basically every case that you were personally responsible for and handled over the course of the last 3 years. The main requirement that they're looking for is how many days of trial have you sat for. Now, days of trial start with picking a jury, openings, direct, cross, closing. So a lot of these trials can go 3, 4, 5 days. I've had trials that have gone weeks. So first of all, you have to be eligible based on how many days of trial you have personally been a part of. Then, excluding trials, they want to know 10 cases that you were personally responsible for each of the last 3 years that were significantly litigated. So forget about just trials. You have to have the trials as the first part. But from there, you have to also show that the majority of your practice is committed to litigating civil cases, not just settling them in pre-lit. They want the docket numbers, they want to know the other side's attorney, they want to know the defense's attorney, and they want to know what judges before. So this is for every single case. And you also had to get recommendations, and this is, I think, the interesting part. You had to get 3 judges' recommendations that you personally tried cases before. But not only that, you had to get 2 or 3 opposing counsel recommendations from the cases that you went to trial for.
Right. So not only do you have to get the trial work in, you have to litigate cases full time, but you also have to get the recommendation from judges that hear hundreds of cases throughout their career, and you have to get the recommendations of your adversary, which is very interesting. They have to certify that you are competent to try cases in order for you to become certified. So everybody at this table is a certified trial lawyer, except Ralph. He's pending certification, and he'll be a certified trial lawyer by the end of the next 6 months after the approvals come out. So with about 1% of the attorneys in New Jersey being certified, I'm going to ask Sean. Sean, what is the first thing that somebody should do when they're involved in a collision?
Well, I mean, number one, obviously call the police. You want to get it documented. I can't tell you how many times people have come in, you sit with them, and they go into the police station a couple days later, because the first thing an insurance company is going to do is look at it to try to diminish the case, to say it wasn't a big deal. Preserve any of the evidence. Take photographs. Go and get checked out. Usually people, the common thing is a day or two later is like the onset of the majority of the pain and the injuries, because adrenaline is pumping. Get checked out by a doctor. Call an attorney, call your attorney if you already have one. But the one thing that you don't want to do, because the insurance company for whoever caused the accident will try to reach out to you, possibly even try to settle the case with you. They do not have your best interest in heart. They are not concerned about getting you better, getting medical care. So that's when a certified trial attorney can really help you start and navigate the course and all the things that are necessary. Number one, to get the medical treatment and to get everything rolling and make sure nobody's taking advantage of you and preserve your rights.
Would you have anything to add to that, Pete?
Yeah, it's interesting. Everything that's been said here, what it really boils down to, I think, with the certification is that it's evidence that you're accomplished in the area of civil litigation. Ralph mentioned you have to get recommendations from judges. You have to have recommendations from your adversaries. I mean, essentially, it's a validation of what a lot of lawyers advertise, that we're a specialist. There are a lot of attorneys out there who say, "I'll handle your case. I'm an injury attorney." But what is an injury attorney? Really, you're not looking for the injury attorney in the sense that somebody has handled the case. You're looking for the certified attorney who can take the injury and then help you manage it. Like Sean said, you got to do a lot of things to get the case in a position where you're going to ultimately be successful at trial. We try, as you've said many times, Lawrence, we prepare every single case as if we're going to trial, and it really starts. A lot of the things Sean said were great. I mean, it's very important. You got to document everything in advance. You got to make sure that you preserve evidence, or you're not manufacturing, but you're making evidence when you're investigating the case. And at the infant stage of the case, at the infant stage of the claim, that's some of the most important evidence. Like Sean said, for instance, don't talk with a claims adjuster. You don't want to talk to a claims adjuster. Their job is to get rid of the case, to throw some money at you, to maybe make you give a statement outside of the presence of your attorney, where you might say something thinking you're being helpful because it's a claim that you want to get resolved, and it may be something that might ultimately hurt you in the case. So I think the main thing about being a certified civil trial attorney is that there are many different elements to it, and there are many different aspects that you have to accomplish in order to become certified, that ultimately all demonstrate your competence as a trial attorney. And I think that's the key thing. It's either your judge, your adversary, your colleagues, your clients, those type of things. You've tried a case, you got a good result from your client. You tried a case, the judge made a nice statement when the certification board contacted him or her and said, yeah, this lawyer knows what he or she is doing. I mean, that's really a validation of what we all work very hard to be, which is the best advocate for our clients.
Right. And I think there's 98,000 attorneys in New Jersey. Remember, just over 1% are certified trial lawyers. Now, that's also includes certified workers' compensation lawyers, which we have at our firm. We have certified civil trial lawyers, and that's all we do is injury law. So it's somebody that's injured on the job or injured in a collision, trip and fall, a construction accident, or injured at work. Could be a products case as well. So remember, when you're hiring a lawyer, look for a certified trial lawyer. If it's a criminal case, you should be looking for a certified criminal lawyer. If it's a comp case, certified compensation lawyer. If it's a matrimonial case, it should be a certified matrimonial lawyer. Those are the guys and the gals that actually do that type of work. For example, any of us could go into tax court. I've never seen a tax court. I don't know where it is, but I still could represent somebody in tax court. You're probably going to lose all your money because I wouldn't know what I was doing. So you wouldn't want to take a tax lawyer or a jack of all trades and take them into a civil trial because they're not the people that do this for a living. We live and eat this every day. This is all we do is injury law. That being said, let's talk about some of the different types of cases and the catastrophic cases that we've handled and some advice for people. Now, Sean, I'll start with you. You've handled some big cases in your day. What are some of the things that separate GGL attorneys from other attorneys and how we handle cases?
I think it starts with what Pete had already touched on. We prepare every case for trial. Every single person that comes through the door, it's not, okay, we'll get you some money, we'll get this case settled. Our number one concern is helping them navigate and get medical treatment, make sure medical bills are paid. You know, the non-economic damages, pain and suffering, loss of enjoyment of life, things like that, you know, they come later on. You know, you're barely scratching the surface. So when I say, you know, we're prepping every case from the very outset of it, we're not waiting until a month before trial and gathering everything and, you know, putting in an entire weekend prepping. It's a matter of learning about your client, learning what their, you know, their story, what their narrative is going to be that you have to tell. Number one is, I think that's the most important thing. Secondly to that, though, is the evidence, especially, you know, when you're dealing with big cases like trucking cases, for example. Trucking cases, as soon as that collision happens, evidence it starts to disappear right away. You know, the trucking insurance companies and their attorneys are very aggressive. So it's important that you have somebody out there right away to inspect that truck, to be crawling underneath it, to be taking whatever data, any downloads. You really, in those types of cases, you file right away because of the amount of investigation that goes into it. What separates us from other firms, I think, is exactly that. And you know, it's the same as like an insurance company. Like, our clients are actual people. They're not file numbers. They're not just a last name. They're not the so-and-so file. You know, this firm prides itself on making sure that our clients are never in the dark about what's going on, that they're aware of every step of the process. They're counseled through the entire thing. I think a lot of times attorneys can get very caught up in, you know, the day-to-day of it, when every client, this might be their first and only accident in their entire life. They've never been through this, where we navigate this on a daily basis fighting for our clients. So, you know, that is our job, and that's what we do so well at GGL, you know, through all the training that we have, mentorship, everything else, is to make sure that every single client is treated like family, you know, being one of the core values that really, I would say, sets us apart from the majority, if not, you know, a lot of all the firms around.
MP, what do you? You've been on the defense side as well as on the plaintiff side, which represents the injured party. What is the difference between a GGL firm and some of the other firms that you've seen?
Yeah, we definitely have a lot of contact with our clients from the very get-go. We have a policy where we want to sit down with the client within 48 hours of the client retaining us, you know, face to face, to get to learn to know that client. I mean, let's, you know, honestly, most people don't want to talk to the lawyer until they have to. They're not planning their next visit to the lawyer unless they absolutely need to. And in our situation, people come to us, they've been injured, they've been in a traumatic event, whether it's a car accident, a fall down. You know, I've handled electric contact cases, gas explosions, and with traumatic, serious, long-standing, permanent effects on human beings. And the difference with a firm like ours, where we make initial contact with the client and establish right off the bat a level of trust, as opposed to a lot of other, like the defense firms. Usually they get a file first. They don't get a person, they get a file with maybe an incident report and maybe an insurance policy or some sort of an investigation that was done by an investigator who's hired to look into the background of the plaintiff to see, whether there were any other accidents, prior accidents, whether the person is posting anything on social media, right? They're always looking for where can we punch a hole in the case? Where can we punch a hole in an otherwise truthful, upfront, forthright, usually very clear liability case with evident damages? It's almost, and I'm not a big Star Wars guy, but it's almost like the dark side versus, what is it? My kids will kill me. The good guys. But that kind of thing. That is really I do believe that. I do believe that's a big difference.
It is a big difference because the insurance companies, the only people that they answer to are their stockholders. So they don't want to pay out anything where we actually represent the injured people. We don't represent an insurance company or a stockholder that's worried about the bottom line. We're trying to maximize the value of a claim and get people compensated for their injuries. We can't make them better. We're not doctors. We'll get them out for the best treatment that they could have, and then we'll get them compensated and try to make them as whole as money can. So John, now you've come from other firms, and you're with GGL now, and you're actually going to do a presentation in a couple of days. Why GGL? So I'm setting you up here. Why GGL? What makes us different?
Well, so I've been practicing for a little over 17 years. I've been at 15 of those years have been for the plaintiff side. I started out on the defense side a year and a half, and I realized very quickly that's not what I wanted to do. But since that time, since making the switch, I've been at about a half a dozen different firms. And the biggest thing I see, I guess, is I've never been at a firm that truly, and we've said it already many times, but truly prepares every case like it's going to trial, that would have no problem with taking every case to trial, and that isn't cheap about experts and expenses putting things into trial. There's a lot of firms out there. I've worked at some of them, well-known firms, good firms. I'm not going to name names, but firms, high-volume firms, where they have a lot of cases, but they don't try a lot of cases. They settle. They turn everything over. And at the end of the day, they'll take whatever the offer is to settle that case rather than go to trial. And there's a lot of other firms, even the firms that do try cases, they get cheap about experts. They don't want to spend the money on, 3 experts. They want to just try to do it with 1 expert.
And just to jump in there, John, because people won't know, how much does an expert cost? Your average doctor, orthopedic surgeon, or pain management doctor, how much does it cost to bring into trial?
Average pain management doctor, $3,500 to $4,000. Neurosurgeon, $5,000 to $6,000, maybe $7,000. And these are expenses that the firm is forwarding into the case, that if we lose the case, we're just going to lose that money.
Right.
So there's a lot of firms out there, even the firms, where I did try a lot of cases, that were very cheap about experts. And it was always, I felt like I was always fighting a fight with one hand tied behind my back. And I've never, coming to GGL, it's been, I'm shocked how we're not cheap at all. Lawrence, you have no problem putting whatever expenses the case needs into it, hiring whatever experts we need without really even asking any questions usually. And also really encouraging us to take every case to trial until we get to that point where it really just doesn't make sense. There's a point at which it is smarter to settle the case. But unless we're there, you support us and you say, try the case. And when I started at GGL, I've been here a year and a half, I was thrilled because I thought that I was going to get to try a ton of cases. I love trial. If I could be on trial every week, I would. And last year, in the whole year, I only got to try one case because every other case, at the end of the day, and sometimes it was after picking a jury or showing up for trial and ready to go, all of a sudden the insurance company has our demand.
Right, and that's something that people have to understand is that an insurance company is going to dangle carrots. They're going to try to get you to settle for less. The only leverage we have as plaintiff attorneys and you as the victim is to take the case to trial, because then it goes into the hands of a jury. The jury's going to decide how much that case is worth. So that's when you're going to see the maximum value of your case. But the only way to get to that trial is having a reputation that you are going to try a case, you're good at trying cases, and that you're prepared, and you've spent $20,000 or so to bring in those experts. That's when the insurance company knows, okay, it's time to turn over the full value. Now, Ralph, you've been with us over 5 years now.
I'm going on my 7th year.
All right, so talk a little bit about what it's like at GGL and how we prepare cases.
Well, I think what sets GGL apart from other law firms is the willingness to try cases, but also the ability to try cases. I mean, you're sitting right here, we were just saying 1% of civil trial attorneys are actually certified. You're sitting with 5 of them right here. That's already a decent portion of it. So the ability of the lawyers that are at GGL is something to be said for. But also, this is something that I think goes to the point we were just making, but takes it a little further. The defense, the insurance companies, get to decide what cases they want to go to trial on. They can decide, do we want to settle this case? Do we want to not settle this case? As plaintiff's attorneys, we can only say, this is how much we're willing to take. If you don't offer that, then we have no choice. So GGL decides what that number is with our clients. We say, this is the number that can settle the case. If the insurance company is unable to get to that number, that case is immediately marked and prepared for trial. And it's prepared by some of the best attorneys in the state.
Right. Now, let's go back to you, Sean. What kind of cases do we try?
So this kind of leads into, because I did forget to say something about what sets us apart. Types of cases that we try. At GGL, we try the cases that must be tried in order to get our clients the compensation they deserve, the full compensation they deserve. We're not trying cases, and a lot of firms are, because they have to, because they didn't work it up correctly, the things weren't prepared, their experts aren't, whatever it might be, and on the other end of it, there's an insurance company saying, statistically, we're probably going to win this, so we're a no pay on it. At our office, the cases that we try, they can be in any magnitude, across the spectrum, whether it's, a personal injury case, medical malpractice, a trucking accident, like I said, the workers' compensation, premise liability, construction accidents. It's whatever on that in the civil realm that we're seeking damages for our clients to try to make them whole. That's what's going to go to trial. And like I said, we're not trying them because we're forced to. It's our choice, because we know that what the insurance company is trying to do is not the best for our client. And I think it was John that you said, some cases, they do need to be settled, because there are, those balancing points in every case. But with that being said, a lot of firms will, not have the things prepared. I can tell you, in the 20-some years I've been practicing, I've tried cases for well over a dozen firms that would call me, a week before they were going to be scheduled for trial, and somebody is certified, and they would just say, they're like, look, they were freaking out. Can you take this case over? And I would have to parachute in and pick a jury and prep the file and take the case over, because there's just a lot of people that don't want to try cases, and they're just not comfortable with it because they don't do it enough. I think everybody up here would agree, the more that you are in court, the more that you're trying cases, the more fluid you are, the more experience that you gain from every trial, whether a win or loss. There's always something that you take from that, and we collaborate with all our attorneys. Every other week we have a trial college with every personal injury attorney that we have is on there. to go over tactics, to go over strategies, to go over new case law developments, what's going on in what counties, how if somebody had a recent trial, how it was prepared, different things like that we're constantly building on and mentoring our younger attorneys too, which I think is a great, very significant thing that sets us apart as well. But that is what would set us apart, especially with the trials from other firms, I would say.
Yeah, and I give the example all the time. I started 16 trials one year. I took 8 jury verdicts, won all 8, and the other 8 settled for the number I was asking for. But what's relevant about that is the next year I tried 1 case because everybody knew this guy's going to try a case, he knows how to try cases, and he's probably going to win. So they start paying you the money. And we just had another example of that. One of our attorneys up out of our Hackensack office in New Jersey tried 4 cases last year, and then he just settled a big case for over $1 million because they're like, all right, this guy knows what he's doing, he's willing to try a case, they're going to pay him the full policy. They don't want to get hit for an excess verdict. So talking about that, so John, what have you seen with the value of your cases? You've been, like you said, with a few other firms. What do you see with the value of the cases that you're able to settle for here as opposed to being with some other firms?
So I have never settled cases for the values that I'm getting at GGL at any other firm. And like I said before, which I guess I didn't fully explain it, when you first hired me, Lawrence, 1.5 years ago, and we talked about the values of the cases, I thought, this guy's crazy.
You're not the only one. I'm hearing that a lot from people that come to the firm.
I thought, this is fantastic. I'm going to get to try a ton of cases. And I mean, I was already certified,
Right.
but I love trying cases. And I think it had been a year before. I had gone a year at my last firm without trying a case, just because, that's how it was. But I was thrilled. I thought I was going to get to try all these cases because, frankly, I thought your numbers were a little crazy. But lo and behold, every time I show up for trial and they know I'm ready to try the case. And I mean, I'm sure partly it's because they know that I'm a certified civil trial attorney.
Sure.
And they know that I've tried cases and I have no problem trying a case. But they also know that the firm's not going to back down, and that when we say this is what we want, this is our demand, that's our demand. You either get to that number or we try the case. We're not, exaggerating or bluffing. We'll try the case. And like I said, last year I only got to try 1 case because every other time I showed up and picked a jury or was ready to go, all of a sudden the insurance company came up with our demands.
And we've hired people from the insurance industry that come in, and when we put a value on a case, they're like, oh, we're never going to get that. And then all of a sudden they're like, oh my God, we did get that. And it's just based upon the reputation of the firm. So Rob, you've spent most of your career with GGL. So talk a little bit about the values and how we come up with those. And a value is how much that we will settle a case for or will recommend to a client, because a client, actually, it's their case. If we think a case is worth $100,000 and they want to settle it for 20, we'll do our best to talk them out of it. But at the end of the day, it's their case. I've spent about 95% of my career talking people out of taking money, and about 5% saying, hey man, that's a lot of money for your case, it's time to settle. So it's normally, we're going to tell you not to take the case. What's your experience been? Or not to take the value?
So, as an attorney, I'm sure all of you guys probably have dealt with this question. I probably deal with this question every day. A client comes in, they were just involved in a crash or collision. The first thing they ask you is, what is my case worth? Right? So what are the things that go into what makes a case valued at what we believe it's valued at? Level of treatment, what type of invasive treatment they've had, conservative treatment they've had, the age of a client. We take into things like consideration property damage to a vehicle, what would these photographs look like at trial? But at the end of the day, as trial attorneys, when that client walks into your door and you meet them, you're already evaluating them to say, how will this person appear on the stand at trial? That's what I'm doing day one when I do an intake with a client. Is this person believable? Is this person likable to a jury? How badly is this person injured, and are they able to articulate that, and how an injury has changed someone's life? Because as trial attorneys, that's our job. Our job is to convince 6 strangers that they should award our client fair compensation for these injuries that have changed their lives. So when we value cases for settlement, we take into consideration what a potential jury would award our client, what an insurance company would consider paying on a case like that. You have to consider things like future medical treatment. If you have a very young client, you have to take things into consideration like health insurance liens and future medicals. And at the end of the day, when that jury sheet gets presented to the jury and it says what pain, suffering, damages, do you believe should be awarded to the plaintiff, that's what we're taking into consideration when we come up with the value of what we think a case is worth.
Right. So Pete, you've been on the defense side and the plaintiff side. What is your thoughts regarding GGL and why choose GGL, why we get better values than a lot of firms out there?
Yeah, I mean, we prep every case for trial. From the beginning, when the client walks through the door, like Ralph said, I mean, you're assessing.
And I know the people watching are probably saying, don't all firms do that?
Well, no. I mean, one of the things, and it's true, one of the things Ralph said is I'm assessing that person right off the bat. So one of the things that a lot of lawyers don't do is ask the person who's going to testify for you at trial about how you are now after this injury occurred, but more importantly, how were you before the injury? Another thing I wanted to point out is this isn't just for potential clients, this video. I mean, we have lawyers as certified trial attorneys. Under the rules of court, we can pay or share is the better term, a portion of the attorney's fee with a referring attorney without that attorney doing any work on the file. And that's important because a lot of people who get in a crash or fall down or have involved in a fire and are burned or whatever the case may be will say, I want to go to my lawyer. And what is the one thing that most of them have done in their life, the most important thing they've ever done? They made the biggest investment in their life. They bought a piece of real estate. So they go to the real estate lawyer, who might be the best real estate lawyer. I might go to the real estate lawyer for a real estate deal, but I'm not going to go to the real estate lawyer for an injury case. And it's important for even attorneys who might not do personal injury work to listen to this and understand that they can send this type of case that they don't specialize in to our firm and be assured that, one, they're not going to lose their client because we're not interested in doing real estate closings. We don't do that here.
Right.
And two, they're going to get probably much more of a return on that case because we're prepping it for trial. We're maximizing the value as opposed to some attorneys like John alluded to might take, the first or second offer. And maybe if the policy is a $25,000 policy or if $50,000 or $100,000 policy, save the insurance company some money, take less than the policy. On these lower policy cases, which we really haven't talked about, and there are quite a few of them, we treat them the same as the bigger cases. And we're always looking to get that policy because that's all our client's going to get. So, it's another, the difference is in the approach that we take towards every single case.
Yeah, what Pete is saying here is that we always get a before and after witness. You need people, because you don't just want to put the victim on the stand, you want to put people that knew the victim before and after the collision or the injury to testify as to how they were before the injury and how they are after. And it really brings home the facts of the things they can't do and the life they enjoyed before the collision or injury as opposed to what they can enjoy after. So again, showing back to you now, we're talking a little bit about referral fees. So if there's any attorneys out there that do not practice personal injury law or workers' compensation law and they want to refer us cases, we will pay you back a third. You only can do that if you're a certified trial lawyer, and as you can see, you have certified trial lawyers at this firm, and we're more than happy to pay you back a third, and we will maximize the value of that claim. So back to you, Sean. Differences in GGL and other firms we've talked about. So how do we really go about maximizing this claim? I tell people it's so simple. Like you start, you have to get certified records. So you get certified hospital records because then you can introduce those into evidence. They cost more, but if you don't, you can't introduce those to a jury. So a jury can hear about them, but they can't actually see them in a jury room. So what are some of the other things that we do that separates us from your average jack of all trades attorney?
Sure. And before I even get into that, I just did want to touch on one other thing about what separates us with the not just the trial prep, but the going to trial, like John was alluding to, is I don't know of any other law firms that have, a managing partner, CEO that was one of the best certified civil trial attorneys is in personal injury in the state of New Jersey, that has your back through anything. And it was like you were talking about, John, with respect to paying for experts, and some firms are cheaper. And I have absolutely seen that. And it's not just that you have everybody's back. It's the mere fact of we have this inclusive group of attorneys that even though physically they're not walking into in the court with you, that everybody's there. It's not just some David versus Goliath. We have a couple Davids. We have a big group of Davids collectively that are all there to help swing. I think that was something I did want to touch on before. As far as what sets us apart from the other firms, because of the fact that we have the individual attention with our clients, that we know them, we know more than just their name, and maybe if they bring their kid into the office, we might remember their daughter or son's name. It's not that at all. It's when you're prepping for trial. Like, yes, you have to deal with how you're going to introduce the evidence, and as we prep throughout the case, everything we're doing is to make sure that things are going to be admissible. Our experts are qualified. The reports will withstand any motions to bar them for being net opinions, and whatever else an insurance company might want to fight you on. But we need to go in with that, and when we prepare the case, we go in to tell that story. We're not there to try the case that the insurance company wants us to try. We're not there to tell war stories and laugh, while the jury's out or we're in the judge's chambers about, this one time I had this case. Because I've never seen any one of our clients that thought that this was a laughing matter. These are serious injuries to people that has just changed their lives. There's things, even little things, and this is why you need to know your client. Because what does a jury pick up on? In New Jersey, you can't ask for a number, talk about money whatsoever, when you're doing your opening, your closing, or any time during the trial. It's up to the jurors to just use their common experiences, and they're directed by the judge to, evaluate that to determine what they think would be a fair, reasonable compensation for pain, suffering, and loss of enjoyment of life. And, when you get to that, it's a lot of the medical testimony the jurors will hear from the doctors, and sometimes it's hard because doctors can talk above our heads a little bit. So it's like, what can they pick up on? I always tell the clients, I say, I want to know, I don't even care now if brushing your teeth, you have to do it with the other hand because your shoulder, because it causes neck pain. Bending over to tie your shoes or put your socks on in the morning. That's something we take for granted, not being injured on a day-to-day basis, where when you have those little inconveniences, and those are just little small examples that go throughout your day. I mean, that's just waking up before 6:30 a.m. You're already experiencing these. And a lot of these are permanent injuries that they're going to deal with. So when you can explain that and paint that picture for the jury of how somebody's life has been changed and how it's going to continue, one good example that I always bring up if it's relevant, not being able to pick up your young son or daughter, not being able to pick up one of your grandkids or get down on the floor and play with them. As being a father of four, that is one of the most impactful things, I think, in my opinion, but it's also one of the most relatable things because everybody has either nieces, nephews, kids, grandkids, friends' kids, and to be taking that away from somebody because of somebody's negligence, not even just gross negligence, just negligence that caused a collision or a fall or whatever it might have been, it's the most important part of every one of our clients' case.
We're going to talk about some actual cases. Of course, we can't use names because it's privacy violation. We have an attorney-client privilege, but we can discuss the fact scenarios of different cases. One thing you need to remember is that insurance companies are multi-billion-dollar corporations who never want to pay out on a claim. They make their money by taking in premiums and not paying out full value. So it's our job to try to get the full value of every claim from them. Now, one of the examples I can give is I had a case with a severe burn. Person had burns over 80% of their body, they weren't supposed to live, had orthopedic injuries, and we went into what's called a mediation. That's where a judge is sitting down with the defense counsel as well as the plaintiff's counsel, and they're discussing the value. So we went in for this one person, and we had a team of lawyers. None of the guys at this table right now, we went in with a team of lawyers, and the defense lawyers were from Los Angeles, Chicago, and Houston. Brought in, it was a big case, and they came in and said, we're here, we're not going to pay a dime on this case. That was their position to start the day. And I looked at one of the attorneys who said, all right, let's just leave. I said, we're not going anywhere. They didn't fly in top lawyers from around the country on a no pay. You send an email for that. So it was just a bluff. But we called their bluff, and we ended up settling that case for a significant amount of money. Can't really discuss it as a non-disclosure, but it was a huge case. But those are the types of things that you have to be willing to go in there and say, I don't care who you are, who these lawyers are. We're not intimidated by anybody. We will try a case against any lawyers around the country. They can bring in the top lawyer for a nursing home malpractice case, a medical malpractice case, construction cases. It doesn't matter to us. We're going to take this case and we will take the case to trial, and we're not intimidated. John, I want to give an example of some of the cases that you've handled in your career where they tried to undersettle and you weren't intimidated and you maximized the value on that case.
Sure. I mean, just recently I had a case of a trip and fall at a workplace. Very difficult liability.
And liability is you have to prove negligence. You have to prove that the other side did something wrong. They breached some sort of duty.
Sure. Yes, that someone was negligent. So it was a difficult case to prove, I would say. The client also had a number of prior injuries and other accidents. So it was a difficult case. Liability was tough. The client had a lot of other subsequent accidents, prior injuries. For most of the case, there was no all for one at all. It was two large, there's a non-disclosure agreement, but there were large law firms, big insurance companies. We ended up going to mediation, not at my suggestion. I would rather, like I said, try every case, but one of the defense attorneys said he thought it would be a good idea to go to mediation. The mediation started off with the judge telling me that my case was worth about $50,000, which I was about to walk out of the mediation right there. He convinced me to stay towards lunch, but that ended up not settling the case. We had to put, probably around 4 or 5 doctors on video. We had to videotape their testimony for trial. All of those went in my favor, from my perspective. And at the end of the day, we ended up settling the case for around $500,000.
So 10 times what, if we wanted to do one of those cheesy commercials, 10 times what the insurance company offered, right?
Exactly.
So Ralph, I know we've actually had a few cases together. We've had a couple multi-million-dollar cases together, but talk about anyone you want that has settled for a much larger number than you thought we were going to receive on it.
Sure. In New Jersey, and I know you've had some podcasts on this topic before, but in New Jersey, if someone gets hurt at work, their exclusive remedy is generally a workers' compensation case. So when someone gets hurt at work, they could be hurt due to the negligence of someone that is not their employer. Typically, these cases are extremely difficult to litigate. Not a lot of information is known, and that I think is one specifically that I recall, you and I handling together, in which we represented a client, a hardworking gentleman who, to be totally truthful, didn't really know how he was injured. And it's very difficult when you have to prove negligence, you have to prove somebody is at fault when you don't really know what happened.
Well, it was difficult in this case, if we're thinking of the same one. He had a closed head injury or a brain injury. Couldn't really remember the facts of the incident, but as time went on, when we went back over the evidence years later, he remembered how he
When he had to relive it.
Right.
And that case specifically involved significant motion practice,
Yes.
because the insurance companies can act like a bully to victims, and they are paper bullies at
Now,
that.
I'm going to jump in there. What people don't realize is that the defense gets paid by the hour. So the more they work and the more work they make us do, the more they get paid. But we don't get paid by the hour. We get paid by the results. So if we don't win, we don't get paid, nor do you. So that's why they try to bully you, because they want us to put in a lot of time on cases, so maybe we'll undersettle it because we're putting so much time in there.
That's exactly right. And in that specific instance, I think 5 different defense counsels filed summary judgment motions, which summary judgment motions are dispositive motions when a party is trying to get out of a case, basically arguing that they have no legal liability or the facts don't support the cause of action. They are very tedious motions to respond to, and it was clear that they were using as a tactic in this case to all team up together and to try to get that case dismissed, which they had different ideas about how they could do that, but ultimately we were successful in defending those motions. But really, I think what got that case going was that between you and I took the depositions of probably 15 to 20 people in that case. And I said, if anyone knew what happened that day, if they were there that day, if they signed a timesheet that day, I was taking their deposition. 15 to 20 people later, we started to have a pretty good idea of what happened that day and what parties were negligent and liable to our client. And after 2 or 3 separate mediations, John had just talked about a private mediation. This case was a very large case due to our client's injuries. It had to go to mediation 3 separate times, in which I think you were forced to walk out of a mediation one day just because the lawyers for the insurance company were just not anywhere near where we knew the case should be. So a little teamwork on that one, but the case ended up settling for multi-million dollars.
Multi-million dollars. From something that was going to be zero. The case was dismissed early on. We got it reopened through all these motions that Ralph was talking about. So it went from this person receiving nothing to receiving several $million. So, and that's just a matter of a great amount of work by the GGL team. Ralph, that was leading that team, put in, I can't even tell you how many hours. We're talking months and months of work on this one particular case. With the amount of time that went in between the depositions and the motions. But that's what we do at GGL. You have any good stories for us there, Pete? I know you always do. So
Sure. I'll talk about a case that went to judgment. It's an odd case. You would think it would have been a simple case. It was a dog bite or dog attack case in this instance. Dog bite liability, the dog bite statute in New Jersey provides absolute liability to the dog owner when the dog bites.
So in English, if your dog bites somebody, you're responsible for that. So don't have your dog bite anybody. It doesn't matter why, except if the 2 dogs are in a fight and somebody reaches their arm in between 2 dogs fighting. That's your only defense. Other than that, you're responsible for your dog. Go ahead.
So they're generally fairly straightforward cases from a liability standpoint, and because of the nature of the dog bite, the injuries could be rather significant and complex. In this instance, this case is actually still open post-judgment. This case was brought to judgment last year in Essex County Superior Court, and the award against the dog owner was in excess of $2.1 million. So there's a judgment outstanding against the owner of the dog. The case was interesting from a standpoint where the bite occurred was where the owner of the dog lived. However, the property was owned by his mother-in-law at the time of purchase. she bought the property and then transferred title to, didn't transfer title, took out an insurance policy, and when she took out the insurance policy, she verified to the insurance company she was going to buy this property and reside in it as her home. Well, she bought it, moved her daughter and grandchild into the property, and then the dog owner came in and essentially created a kennel of dogs on 5 acres in a rural county in New Jersey, and was basically breeding dogs. So there were insurance coverage issues in this case. Sure. The insurance company, we sued the mother, we sued the owner, we sued the daughter and the husband of the daughter who owned the dogs, and we ended up with an owner, the mother, passing away before her deposition could be taken. So there was a lot of testimony that could have been dispositive on some issues regarding responsibility for these dogs that was never going to be able to be established because of the death of this person. Sure. Who passed away mid-suit, very early in the suit, actually. So, make a long story short, the client was bitten while she was turning the dogs out in the kennel. It was during COVID. She was a veterinary technician and looking to make a couple extra dollars, not as an employee of this guy, but as basically a contractor. I'll turn the dogs out, I'll clean your cages, I'll bring them back in, and the Italian Mastiff attacked her. Bit her on the arm. Luckily, she put her arm up in front of her face, so it didn't take her face off. She was transported by ambulance to a local hospital, then from that hospital to another hospital by airlift, where she had to undergo some emergency surgery.
She almost bled out.
She almost bled out a couple of times in the actual chopper. They did 2 types of surgeries, an ulnar release and a carpal tunnel surgery, and then she had some obvious significant scarring on her arm, and she's fairly young, in her early 40s. So because of the odd situation with the ownership of the property and the dog, there were insurance coverage issues. So this case that was, again, they're normally very straightforward, simple cases, became a mammoth insurance coverage case. And there were motions made by the insurance company to get out of the case, to not provide coverage for this event. And what we did, and again, we try to maximize the recovery and try to be smart. Like John says, there's a time to settle and a time not to settle. In this case, I got to do both. I was able to get a settlement from the insurance company while these motions were pending for a fairly significant amount of money. I was able to get an additional several $100,000 contribution from one of the spouses who, by that time, had, again, as my real estate example, went to a real estate attorney and had the property put in her name while the lawsuit was pending, which was probably not the brightest thing to do, because now there's an asset that can be attached in the event of a judgment. So she wanted to get out, and it left the owner of the dog as the remaining defendant, who basically told me, well, I'm going to go bankrupt. I said, okay, that's fine. And we ended up trying the case against the owner and getting that judgment. And of course, when I started to levy on the judgment, so I'll explain post-judgment. When you get the judgment, it's not like the money falls out of the sky and you can give it to your client. You have to collect it. So in this instance, we had to record the judgment as a lien, send out something called an information subpoena, which is a document that basically it contains questions that have to be answered under oath by a judgment debtor, so you can try to find out where the assets are. And you can take a deposition post-judgment to ask questions under oath of the debtor. Well, this debtor was not cooperative at all. I had to make a subsequent motion to the court. Again, this is all post-judgment, to hold him in contempt, to have him arrested, and then he ran to bankruptcy court. So you would think that's the end, right? You went bankrupt, that's it. Well, it's not the end. And this is, again, why we fight every case to the death. It's like, it's in our nature, I guess. I mean, it's in my nature, at least. And what we did was I took a little bit of her money, and like the real estate lawyer who should hire us to handle the case, I hired a bankruptcy attorney to file a proof of claim in bankruptcy court. and a non-dischargeability objection to the judgment. And where we are now, I don't want to, again, it's a pending matter, so I don't want to say too much about it, but where we are now is the trustee in bankruptcy has filed an application to hold the debtor in contempt. The trustee actually retained counsel, rather, to do that. And then our attorney has just filed a contempt order to either have this debtor produce information regarding assets, because still breeding and selling the dogs at what he testified to in the bankruptcy proceeding at about $5,000 a dog. And the litters are big and they're off, and there's money there for our client. And again, will we ever get to 2.1? Maybe, maybe not. But if we get the judgment, if we can avoid discharge of the judgment, then we've recorded our judgment as a lien, and this isn't somebody who's got a few years of life left and might want to ride it out. This is somebody who's got decades ahead of him, may want to purchase something. It's going to have to bring him to the point of having to deal with our judgment. So that was a very interesting, challenging, fascinating case where we were able to fight for our client, do the noble thing.
Right. If that sounds very complicated, it's because it is. But that's what we do. It's not complicated to us. Just like if you're a carpenter and you're doing some fine work, it would be very complicated to us, or if you're a plumber or electrician, we wouldn't know how to do that. But this is what we do every day. So it probably sounds very complicated to a real estate lawyer or a matrimonial lawyer. That's why you come to GGL, to handle these types of complicated cases. I'm going to get to Sean in a second, but we've already talked about a slip and fall on the work site where somebody had a closed head injury or a brain injury. We've talked about somebody with a dog bite. The case I was talking about had significant burns, and John was talking about a trip and fall with significant back injuries. So now we'll go to you, Sean.
It's funny, 'cause as I was sitting here listening to everybody, I was thinking of a case. It's still going on, but it's been an interesting case. And the reason being is it was rejected by another law firm. They came into us, it was after the accident. So unfortunately, for the first 9 months, we weren't able to get initial investigative details and data. But when it came to the office, knowing that we already missed up on time, we filed suit on it. Being that this was a trucking case where the rules are much different when you're dealing with the trucking litigation. You're talking about catastrophic injuries. Usually, you're dealing with trucks that can weigh up to 80,000 pounds. If they're covered under the federal motor carrier safety guidelines, if that applies, if they're interstate, there's a lot of things that it makes those cases much different than an auto accident that's covered by Title 39. And in that, and the reason that they have their own guidelines is because trucks can be death machines. They're barreling down highways, and the first thing that goes wrong, the size of your car, versus a tractor trailer or a triaxle dump truck, the odds are not stacked in your favor. So we have this case. We get everything moving, get it into through litigation. One of the big differences that I know between your motor vehicle and your trucking cases is the mere fact that trucking attorneys, they do not want discovery out there on their companies. And the reason being is everybody's afraid of punitive damages, because it's unbelievable how unregulated the trucking industry is. The last data that's available for all the crashes is 2022. That's verifiable. There was over 2,000 just in New Jersey, and it's been on an upward projection of 100 more every year. And the reason it was a little lower in 22 was because of COVID, and then stepping up again. Out of that, nearly 100 of those are fatalities, and that's just and New Jersey is a small state for that many accidents. So anyway, they do not want to give up discovery, and this one was specifically funny because of the fact that we were pressuring them with, I think it was like 6 motions to try to get the driver's deposition, to the point that they did every tactic possible. They split the driver from the company, hired another national trucking firm to come in as defense, and now there's 2 of them there. to battle against me, and they wanted to go to mediation. Klein didn't even have his surgery yet, and they were willing to go to mediation on it with an acknowledgement of that, and stipping liability to get the case resolved. And we said no. We've been pushing for over a year now for this deposition, to the point that one of the emails said, "Look, we know we're going to pay you a boatload of money." To many attorneys, that would sound amazing to go to mediation. You're thinking, "Oh, that's my mortgage," or whatever it might be. But no, so that made me digging in harder. I said, I want this deposition. Like, clearly, whether or not there's anything there, I don't know, but they don't want me to have it. And that's exactly what it was. And I remember taking that deposition of the defendant driver. It was like a 5-hour dep. And Lars, you were actually in the office, and we took a break, and I came in, and I said, you're not going to believe this, but the employee rolled over on the company, and that case took a completely different turn than it was. But that's one of the things. It was just like we were talking about, like prepping and building a case for trial. If we didn't have that passion and the commitment to our client, if we didn't have the ability to take on these billion-dollar companies, if we didn't have the magnitude of our attorneys, the fighting power, that case would have been settled probably before it was even put in litigation. The client maybe wouldn't have never even been able to figure out how to pay for his surgery to try to make him better. It was a bad injury. It was catastrophic injuries. And that's progressing now. Now we're moving forward with it even further. But I think one of the most important things to let people know is that, that's exactly what we don't do. We don't take just the first or second offer. We don't even take or entertain them when somebody say, we're going to give you a boatload of money. Like, that doesn't cut it. That's not, what we're looking for is just a payday. There's much more to it, because especially in these cases, and one of the things with this client and most of them in these types of accidents is they want to know that somehow this is going to impact and make some type of change on the insurance companies. Insurance companies, especially truck buyers, are not going to put a billboard saying we're sorry and things like that. That's done with their checkbook, or with hitting them on what some people refer to as like a nuclear verdict on punitive damages. That's how it sends a message. That's how you start to effectuate change in the industry with our legislators and everything else for safer driving and safer roadways. We're here to help people after the catastrophic event. But as part of what we do and with our clients is to try to impact change so other people aren't put in that same situation.
We could go on with a lot of other stories. We represent people with significant burns, people that are quadriplegics, paraplegics, shattered bones, spinal cord injuries, but we are tenacious litigators. We never undersettle cases. We maximize the value of your claim, and we'll treat you like family. I'm surrounded here with certified trial lawyers. I'm also a certified trial lawyer. When you say GGL wins, we win for you. We maximize the value of your claim. We treat you with respect and dignity, and we'll get you paid as much as we possibly can for the injuries that you sustain. Thank you.